Hello, welcome everyone. Happy Wednesday. We're halfway there. Thank you all for taking some time and joining us for Trial Prep, What Attorneys Really Want and How to Deliver It, presented by Paralegal Brief and sponsored by Steno. I'm Tara, the webinar manager of Paralegal Brief, and I am very excited to bring you this brand new session that will give you practical tools and strategies for anticipating attorney needs, organizing critical documents, and building compelling case presentations. I'm really looking forward to hearing from Joe Stevens today and what I'm sure will be a valuable and fun conversation. And just so you know, we will be recording this webinar in case you need to leave early. We'll be sending it to you by email within 48 hours. You can also visit the webinar's registration page where you signed up after today's session to view the recording there too. We're going to send that link to you in the chat box right now. Up next. Oh, Joe, I'll have you just go to the next slide for me.
Sorry.
Thank you. Before we go any further, I just want to thank Steno for sponsoring this webinar and helping us to make this happen. Steno offers exceptional court reporting services combined with best-in-class technology and deferred payment options. Steno was built by tech and legal experts who saw a need for a better experience. They remove financial and technical hurdles so you can focus on the case. From creating bespoke solutions for your technical needs to providing flexible financing, Steno is revolutionizing the way court reporting is done. And you can learn more at steno.com. So thank you again to Steno. Up next, let's go ahead and quickly get some technical things out of the way. Please don't hesitate to ask questions during today's event. You can do so by submitting your questions into the Q&A panel found in the toolbar at the bottom of this webinar window. Great questions always make for a great discussion, so don't forget to stick around for our dedicated Q&A session to get even more insights, advice, answers from our panelists. The chat is also open to share your comments and thoughts as I am seeing come through. Don't forget to change the blue button in that chat box to everyone so you can join the conversation. My wonderful colleague Tori will be fielding your questions and comments today. Tori will be happy to answer anything technical you might have. Feel free to pull up the chat or the Q&A if you haven't already. Say hello. Let us know where you're joining from today. Also, closed captioning is available for this webinar, and to enable this feature, you can select the show captions option in the toolbar. And lastly, if you have any audio issues during today's presentation, you may choose to dial in by phone. All dial-in information can be found from your webinar confirmation email that came to you from Zoom, and Tori can relay it to you in the chat at any point if you need it. Up next. Today, again, I am very excited to hear from Joe Stevens. Joe's diverse professional experience ranges from direct client representation to working 3 legislative sessions under 2 different committee chairmen in the Texas legislature. A graduate of the University of Texas School of Law, Joe combines his passion for legal technology with practical experience to help teams work more efficiently and is now teaching the next generation of legal professionals at Texas Tech University School of Law. So, Joe, with that said, I know we have a poll on screen. We're going to gauge a little bit about where our audience is at with AI, and I'm going to pass everything over to you.
Thank you so much. It really is a pleasure to be with you all. First of all, the chat is just firing right now, and it's so wonderful to see people joining from across the country. And I'm seeing a lot of Texas folks as well, which is special to me because that's where I went to law school and currently live out in Lubbock after spending the last half dozen years across rural Texas. So a pleasure to be with everyone today. And I think this is something that you're going to hear throughout the next hour, really, of which I'm going to speak for about 30 minutes. And what I want to do in that 30 minutes is give you a great deal of content around things that you can practically do when it comes to assisting and preparing and working alongside your attorneys as they gear up for trial. But before I do that, the recognition of the role that you play, and it is beyond critical. I hope you know that, and I hope you feel that, and I hope that you work with attorneys that make you feel that way as well. Because the paralegal is integral absolutely integral to the role of success and the outcome of success in a trial, and not just a trial. A lot of these skills are going to be applicable to pre-trial settings, to contested hearings in advance of trial, to outcomes that actually are results of conversations that never reach a courtroom. So a lot of the work that you do, those silent and anonymous, and maybe not getting the glorious result with a verdict at the end of trial, all of these skills apply throughout. So I invite you over the next 30 minutes to really be as engaged as you are already in the chat. And I'm going to keep my eye on that, but probably save my answers to your questions to the end of my time speaking. The other thing that I really, really want to emphasize up front is that what we're going to be talking about is a combination of soft and hard skills, right? I mean, there's an art and a science to the excellence of legal support. And the science itself is very clear, right? From calendaring to the citation checks to legal research, document management. To me, the really unteachable skill is in the soft skill, is the soft skills, how you work with, how you anticipate attorney work styles. What is it that goes through your mind? How is it that you actually engage with an attorney, who's pacing around 2 a.m. before the night before a major filing, a major hearing? I can tell you for me that in the years that I've been practicing, the difference between a good and a great outcome is often the result of what happens weeks in advance, quietly. The just in case tab that you put together, the exhibit that you decided to sort of take extra note of, the document that you flagged during your third or fourth review. So, excuse me. These are things that we're going to be talking about, the combination of soft and hard skills. I hope that you find it useful. Let me start. I'm going to skip over my background, but I do want to let everyone know that I've done some civil work and most recently criminal work. I built a public defender office in rural West Texas that covered about 12 counties. And we handled obviously criminal matters in that public defender office. But now I teach at the law school and I teach criminal trial skills to different to young students. So we are actually in court all the time and working on the skills that I'm about to teach. So these things are absolutely relevant, and I think something that has universal applicability to attorneys of all practice areas. On top of that, I work for a company called Steno, and Steno, as you heard up front, does a great deal of adds a lot of technological benefit to attorney practice and paralegal practice for sure. We'll get into that a little bit later. Let's just set the table for a second, because as you are all feeling, I don't know if there has been a more transformative moment in the legal practice in the last 30 years than what we're seeing with the addition and the increase of AI tools and how it's disrupting the practice of law. Every single legal tool I'm sure you're engaging with, whether it's Lexis or Westlaw, whether it's your contract builder and manager, whether it's the way that you are handling your case flow itself, everything is being touched by AI in some shit form or fashion. So that's changing the role that everyone is playing now across this entire process. We have a dated and very sort of regimented historical profession that has a very stilted way of doing things, and it's being really affected technologically. So we're going to hear and talk a little bit more about how you can use those to maximize your work product and make your excellent work even better. So these are a few things that we're talking about, and you're seeing on the screen here about the changing landscape of the law itself. What it means to me, though, is that I think that you can't go to a conference, you can't read a bar journal right now without hearing about what AI is going to do in the next 6, 12, 18 months. I think that there should be a lot of calm in the world of excellent paralegals, because what we can do with this technology is going to make your life and your work exponentially better. And what we're going to see over the next little bit here are these different strategies that I'm going to give you and that we're going to talk about. Some, again, soft skills, some more hard skills. And let's just jump right into the first one. This might sound really obvious, but having worked with a number of paralegals in the past, working with a number of legal support staff in the past, I do think that there is a critical difference, and I'm sure that some of you are already feeling or aware of the attorneys that you're working with and how they fit into these different buckets. Some more research focused, some who are really prioritizing the structure of the evidence that is presented to them and is a part of their case. Some who really hone in from start to finish on the story they need to tell, whichever audience they're going to tell, whether it's a opposing counsel, whether it's a judge, whether it's a jury. Your more rapid adapters. This is just a sort of different buckets of attorneys that came to mind when I was putting this together. Your courtroom power players, the people who really just basically say, we're going to figure this out in court, and anything in advance of that is something that needs a little bit less attention. Or the people who are really masters at doing things behind the scenes and engaging in conversation that lead to better settlements. Whatever the style of your attorney is, the attorney that you're working with is, I do think it's the most important first step to really understand exactly who that person is and how they tick, because that is going to tailor the best way that they receive and engage with support. So that's a really soft skill to me. And I think that when you are really tuned in to what that attorney needs, even if they're difficult to read, you'll be able to gauge how you can support them and how you can work alongside them as they gear up for these hearings, for these trials a little bit more easily. Strategy number 2. So the first one is just, again, a high level understanding of who it is that you're working with, what their style is, and taking a moment to really understand who that person is. One easy strategy for me to do that is I've found is when it comes to how I describe an attorney to someone else. What are the most important features of that attorney? And when you do understand who that lawyer is and what matters the most to that attorney, I think that you get into the second strategy here, which is, all right, what organization system is going to match most and match best with the person that we are working with to actually sort of prep them as they go down the road heading towards trial. A quick pause here for a second, too, and I really want to emphasize this. Trial, to me, is something that comes up a great deal in the legal practice. Everyone from day one of law school is taught there's a huge emphasis on the glamour of trial skills, mock trial, any sort of in-court practice that is leading to trial. And it's critical. I mean, it's one of the most powerful tools we have as lawyers, is not just the ability to go to trial, but actually going to trial. As we all know, most cases don't actually reach that point. So even though we talk about trial skills, we're also talking about the ability to match all of those skills in advance of a trial setting. And here, what we have here are the organization styles, which you can see on the screen, that match, I think, best to the different attorney styles as well. So having the different technology that can support the documents, the evidence tracking, the testimony, all the depositions that are coming in and gather the transcripts, how you're engaging with those transcripts. And then the notebooks, the trial notebooks, the preparation itself, exactly what it is, what workflow you're using in each of these instances to support the attorney style that we discussed in the first strategy. As we keep diving a little bit more deeply here, I put as the third strategy something that is obviously intimately familiar, I think, to y'all already, but is something that I think is changing even more rapidly with the addition of technology to attorney workflow and paralegal workflow for sure, and that is document mastery. How is it now that your CMSs, the different ways that you're tracking the interactions you're having with different discovery, with the receipt and delivery of discovery, with the analysis of discovery, with the sort of understanding of what's in your notebook, what you have in your file, what's outstanding, what other questions need asking. What tools are you using to track and know exactly what it is that you have, what it is that you need, what holes are in your case, what holes might be in opposing counsel's case? Document mastery, to me, is absolutely integral to success. And nowhere more, I think, are we seeing the impact of AI than we are with document mastery, whether that's in the e-discovery area, whether that's in where you're storing your discovery internally, if you have a platform or a software that you're using to do that, and to actually log all the time that you're spending analyzing those documents, or lastly, how it is that you're using AI or any other technological tool to engage with those documents to ensure that you are understanding every last detail of them. Before I moved back to Texas, I worked in Baltimore for a year. And worked for a brilliant lawyer there, and a lot of post-conviction appellate work. And, this is within the last 10 years that the way that I would get up to speed on the documents that came in boxes, as you all know and remember, was extremely manual. I mean, I was going through trial transcripts that were hundreds of pages long. I was going through medical records that were obviously hundreds of pages long. And now, in the last 5, 6 years, we've seen the ability for technology to make that part of my job so much easier because it can be tracked, searched, understood, and now, as you're going to see a little bit later, interrogated in a really meaningful way. So, document mastery, what tools are you using to actually understand and process, organize, and maintain the different databases of the thousands of pages of documents that you have? In conjunction with that, and I think very often something that grows out of the document mastery is what we have here with the timeline mastery itself. Um, you know, documents themselves allow you to tell a story, as you know. What it is that you have, getting a lay of the land first with the discovery that you have is critical. I mean, that's step one. But then actually weaving a narrative out of them and understanding what documents mattered, the timeline of those documents, exactly what came through when. I'm telling you things you probably already know and feel and explore. But when it comes to, from an attorney point of view, the ability for me to look at someone who is working alongside me in a paralegal role, in a legal assistant role, in a support role, but as someone who I really see as an absolute partner in the process. And for that person to be seeing from the exact same page, probably even from a higher level, not just the content of what we have in our file, but how that content weaves together to tell a story. I don't know if there's a more valuable skill that you can have than that. So many things are teachable, so many things are trainable, so many things are kind of commoditized, right? The ability to do legal research, the ability to sort of draft and understand different pleadings and filings, but the ability to actually sort of step back and see something that is two-dimensional and make it three-dimensional, and tell a story using the documents, weaving together that timeline itself, and then building it out in a way that makes sense to me, in this case, from my perspective, but then maybe more importantly, to whoever the audience is that I need to be communicating with. Again, is that opposing counsel in a sort of a settlement discussion? Is that a judge at a pretrial hearing? Is that a jury at a trial? Whatever the audience is, understanding how to take the information, process it, build it, and make sense of it and tell it in a compelling way. So timeline mastery, I have a strategy 4 here, right before deposition mastery. I don't really didn't know how to sort of label this slide. I mean, deposition mastery can mean so many different things. But as you all know, the amount of work that goes into a deposition is drastically higher than the deposition itself, right? Preparation is perhaps the most prized commodity, I also think, when I am looking for someone who can really compellingly assist and help and provide like absolutely irreplaceable help as we gear up to trial. And one of the steps in gearing up to trial, obviously, is going through a series of depositions very often. So the question then becomes, how is it that we walk into that room completely poised? 2 things that I want to say there. The answer to the question that I just gave is ridiculous. There's no way. I mean, we can sort of project an image of calm. We can have an idea that this is going to go a certain way. But the way to mitigate against the extreme anxiety that can come with great uncertainty is not to pretend it doesn't exist, but it is to take steps well in advance of that day to make sure that we have control and answers to every single question that we might have. So we are as prepared as possible to deal with the uncertainty that is bound to come out of the hearing, the deposition, whatever it is that is going to is thrust upon us. So in this deposition mastery section, basically what you're going to be seeing here is that it all boils down to preparation. I was just in Japan over Christmas break, and it was incredible. And one of the reasons that it was, well, this is kind of a nerdy reason for it to be incredible, but one of the things that was amazing is I was walking along and I saw there was a machine that was under construction. And the way that there was a sign hanging on it and the way that that sign read was, instead of something like under construction, please do not use. It was translated from Japanese and it said preparation in progress. And it stopped me in my tracks because the lawyer side of my brain is always thinking that that is in this situation, that is the perfect way to describe something that is a way to grapple with uncertainty. The preparation is perpetually in progress. And I think that you become irreplaceable to this process if and when you find yourself in a spot where you can anticipate as much as you can, and you're working alongside counsel to prepare the mightiest way possible in advance of whatever setting it is that you're walking into. I'm seeing a question in the chat, which I'll get to a little bit later. What AI-powered tools are people using to improve their document organization and management? I'm gonna actually show you one in a second that I find to be useful, but I want to show it to you not because I find it to be useful, and not just perhaps because it's one of Steno's tools, but it truly is something that is revolutionizing the way that we can get to the level of preparation that I was just discussing. Strategy 6 should say exhibit management. It says exhibition management, which sounds a little fancier, but let's just trim off the ION at the end there. It's exhibit management. Right, this is something that this is a hard skill that you all are probably familiar with. What systems do you have in place to manage the massive number of exhibits potentially that are going to be introduced? Are you using tools, in-person depositions? Do you have the right tools technologically if you're doing virtual depositions to pre-mark exhibits, to have the exhibits uploaded, to have them, make sure you're uploading the right ones at the right time, to make sure that there's a sequence to them? There's plenty of tools out there right now that really handle exhibit management. And I would invite you, if you're at all concerned about how that flows, or if it's going to disrupt an old workflow, to really just kick the tires on it. Just try some of this new technology and see if it's actually going to benefit the way that you actually engage with your own workflow. I can't emphasize enough how strategy number 7 to me is just it's everything. I bristle when people talk about what AI is going to do to paralegals or lawyers or court reporters. It's definitely going to disrupt the industry. There's no question about that. It already is. But when we have all this technology now, when it is correctly deployed, I've already seen it make people so much more irreplaceable than they were even 18 months ago. Because it allows you to pick and choose from a host of new products to actually become the partners that I think lawyers are very often looking for. When I feel like I'm sitting in the room with someone who's 2 steps ahead of me, and they're 2 steps ahead, not necessarily because of their certification or where they went to school. In fact, it never has anything to do with that. It has to do with what they've done in advance of coming into the room to have the discussion that I want to have. And they can immediately refer to the documents that I've overlooked, or they immediately can correct me when it comes to a sequence of events that I may have sort of rushed through because I was doing something else. Or they can really digest a tremendous amount of information, which technology is allowing us to do, and give me the sort of page line citations that go along with that. You become the ultimate partner. I mean, it is. I can't even convey how that feels, but it is the softest skill and yet the most important one to master. If you can be prepared and poised in high pressure situations, let's go to work together. All right, trial. Again, the elusive trial. I really am so interested in knowing, it was a question, a poll question that preceded this. Of the people who are watching and engaging with this today, how many people have actually been in a trial setting? In the last 5 years, I've hired a number of lawyers in different offices that I worked in, and it is just so rare for lawyers to get in a lot of fields into a trial setting, and therefore lawyers aren't getting involved. I mean, the actual in-court practice itself, it used to be a little bit more trial intensive. Some of you work for attorneys and work with attorneys that are courtroom warriors, and are in trial probably all the time. Others are probably feeling the opposite. But everything that we've just talked about, everything that we've just been we've talked about the different pretrial hearings and the different skill sets that go along with that, absolutely apply at the culmination of what I think classically people think of as being a lawyer, and that is stepping into the courtroom for trial. If you can take all of the strategies that we just discussed, you then don't have to do anything extra for the most part, except take them and walk into a trial setting, right? Things are different in trial. There's something that fundamentally changes when you're in trial. Your relationship with opposing counsel is different. The jury dynamic is different. You have multiple audiences at multiple times. It's fatiguing. It's intense. It is making a decision every 30 seconds. It's sitting there anticipating everything from objections to rulings to how to keep things out of evidence, how to get things into evidence. But all of the way that you do that is by doing all of the things that we just discussed in the prior strategies. And it starts with knowing who you're working with, what your case is about, the preparation that goes into all of the lead up to stepping into the courtroom. If you are saving this for a week or two in advance, then you are so far behind. This begins from case size up moment. As soon as a client is retains your firm, or your counsel, things need to be in the works, thinking about what story are we going to tell, what evidence do we need, things like that. And all of that is relevant to trial setting as well. So do you have the technology that can actually allow you to be successful getting to this point and then through this point? And I'm seeing a couple people talking about love helping choose the jury. I mean, there is something really special about being in trial. There's just nothing like it in the world, and I think it's irreplaceable. But it also is something that is a different skill set in and of itself. So you're seeing this on the screen. One of the things I want to highlight here are the real-time operations and the crisis response. Being in trial for me has always been about being the most prepared person in the room. And then secondly, the most poised person in the room when things go sideways, which they invariably do. If I am alongside a team of people who share that poise, then I'm good to go. Those things matter the most to me. It would be interesting to sort of apply that to when you're thinking of the lawyers and the cases that you're working on right now. What things matter most to them and how the support and assistance can be most beneficial throughout that trial setting. Last thing I'm going to say, I think we talked about the poise, the preparation, the ability to sort of be a real strategic partner. This is something that the continuous improvement section is something that I think is what, when I'm around people who really have a sense of self-investment, who really have a sense of, I want to be better at this. I'm a recognition that I'm going to make mistakes, and that when I do, I want to learn from them. Or I want to be sort of on the foreground of innovation in this space. I want to know what this technology means. I want to understand how it can be beneficial. That in conjunction with the sort of self-awareness that comes with, I am going to make mistakes. There's something in that cocktail that is like a combination of humility, excitedness, pride, all of those things that I find extremely appealing and compelling about wanting to invite someone to be a strategic partner of mine on a case that I'm working on. So if you are in this frame of mind where you want to continually get better and are aware that there's going to be missteps, I mean, that's a brilliant set of features in how I think, especially a paralegal, but anyway, maybe this is just a general life principle, quite frankly, but can be exceptional at the job that they do. So you're seeing on this slide here, right? Everything from professional growth to, being on the foreground of different technological innovations. But either way, day to day, aspiring to be better, aspiring to understand what went wrong at trial, what went wrong at that hearing, how I can do things differently, how can I support better? I mean, that's a question I ask legal assistants and legal support all the time. The terminology can sometimes be a little wonky because when I'm asking how I can support them better, I'm really looking at them and saying, this is a team game, and I mean that. how can we actually collaborate in a way that is good for you and good for me and therefore good for the client. All of that falls under the umbrella of continuous improvement. So you're going to see a quote up here about what excellence comes from. This is sort of, I suppose, a little summary of what we've just talked about. And we're going to get into Q&A here in 1 second. I'm going to take 2 minutes because I want to show you in real time this one tool here that you're seeing a transcript on the screen right now. And this transcript right now, this is a transcript of a resolved case. There's no confidentiality issues, and I hope that that was a question that might have popped into your head. This is transcript that is now living and uploaded and is now interrogatable. It used to be when I was sort of starting out too, like that we would look at transcripts and I would control F my way, look at the word index, and I try and understand what was going on. Here is an example of how you as a paralegal can save a tremendous amount of time and cut out a lot of noise. This is a 170-page transcript. Okay, none of you have seen this before. I'm just going to click right here on something that's asking for it to generate a brief transcript summary. And what you're seeing here in real time is AI digesting this entire transcript, which it knows what it is, who the parties are, the flow of parties from plaintiff, defense, page and line citations. And it is now telling you exactly what a brief summary of the transcript is with cross references to page and line citations. There are dozens of tools out here that are doing things like this, okay? Not this specifically, but that are going to, not this specifically when it comes to transcript engagement, but that can affect your different workflow as a paralegal. The reason I want to show you this is when people are asking about, what is this going to do for, what is AI, how is technology going to disrupt the future of paralegals, lawyers? I would have killed to have the ability to take a transcript and then within 15 seconds have a pretty condensed summary of what it is with page and line citations. So at least I get a better sense of what's going on. And what if you want to even take it another level and sort of ask it a little bit more curious things? What about in the case that you might be working on, does it matter if the witness contradicted themselves in the transcript? I mean, is that something that your attorney might find beneficial as they lead into a deposition? I mean, absolutely. So here you have the answer to that question as well. There are a number of instances in this transcript where this witness did contradict themselves. So I'm just showing you this as very briefly as a high-level tool to sort of say, imagine if you could take something that used to take a month, and that is go through dozens of transcripts, and imagine if you could condense and piece together summaries, questions that are important to the lawyer that you're working with. Were there contradictions? What's a timeline of events? Were there inconsistencies? And by the way, you can do this across multiple transcripts at the same time. These are really, really, really brilliant tools that I would encourage you to explore. And I hope that you have some questions about it. I think I can see some in the question and answer session here. So what I'd like to do now is I've got a couple minutes, about 30 minutes of talking. So let me pause, Tara. I think we're in a good spot where I wouldn't mind diving into some of these Q&As.
Absolutely. Thank you, Joe. Thank you so much. What a great, tons of information, great information. Yes, let's absolutely start taking some of these questions. Before we dive into these, just reminding everyone now is the time to get straight from the source insight from Joe. And again, great questions always make for a great discussion at this time. So don't forget to submit any questions that you have into the Q&A panel. And don't worry, we also understand if you need to run. Just a reminder, today's session is being recorded and will be emailed to you within the next 48 hours. If for some reason we don't get to your question or comment today, you can always connect with Joe. His email and LinkedIn is on screen and it will be in the chat shortly for you. All right, so I'm going to start. I'm just going to go in order here. Our first question is coming in from Leslie. Why do attorneys wait until within 1 week of trial to determine the exhibits? Can this be done sooner in the process to give the paralegal enough time to pull and compile, or is there, any specific reason that some attorneys do this?
Brilliant question. There could be a strategic reason. Maybe there was an exhibit that came in late. And maybe that's a critical exhibit. And I mean, there could be a strategic reason, but ideally it's for that reason and not out of laziness. Um, uh, I have worked alongside attorneys. I've seen attorneys in the courtroom who you can tell are prepping too late. I think that one of the great value adds of a paralegal could be, if you do have access, or depending on how you're engaging with that attorney, to suggest or to anticipate or to take charge in that exhibit preparation well in advance. So the answer is yes, there could be a strategic reason. Very often, however, it's a lot of things just happen last minute, and I think that's out of bad practice, or it can be out of laziness very often, and that's frustrating because that doesn't benefit anyone. It puts you in a tough spot. It puts the client in a tough spot, and it's never something that I encourage. It's definitely not something that I teach my students.
Makes sense. Thank you, Joe. Moving right along, we have a few similar questions that I definitely want to touch on. What AI powered tools are you using to improve document organization, management, search and tracking programs? Really, just a lot of questions coming in about AI tools. And then on the flip side, what are some things that AI is not good for, especially when we're talking about attorney-client privilege? So some pros and cons here, Joe.
Great, excellent. One quick thing, I just saw Lee in the chat talk about her experience in trial and arbitrations, and basically saying deposition exhibits are going to be trial exhibits. Also a great point. So there's ways, if you're sort of start to finish with that lawyer, that you can, on that case, that you can sort of anticipate what the exhibits are going to be heading to trial, because they've already sort of found themselves into a deposition. AI, there is not going to be a more talked about legal topic in 2025 and maybe beyond that than AI. How to regulate it, what ethical considerations, attorney-client privilege, great point. HIPAA compliance when you're dealing with sensitive medical records, anything. It's critical that if you're using ChatGPT, everything that you put into ChatGPT, for example, is going to be ingested and digested by that system to train its own model. So you are really in a violation there of a lot of security, and I would argue from a legal perspective, your ethical duties and obligations. If you're going to be using AI in any sort of legal workflow, you've got to be checking to make sure what parameters exist from a security perspective. I was just showing you this product that Steno built. One of the things that Steno also talks about, and I would apply this to, I've seen it with Adobe, I've seen it with Lexis. They will have a page where they talk about their compliance and whether or not it's HIPAA compliant, or whether or not there are privacy compliance issues, and how they deal with it. You have to do the initial step of investigating what those are. And in the tool that I just showed, for example, that transcript lives and stays and just lives and dies in there. All the questions that are being asked stay in there, and it's not being used to train any model. Excellent question, but it's such an evolving landscape that I'm not really sure how that answer would change in 6 weeks or 6 months. But I think that the initial step is going to remain checking in on all the security requirements and the security parameters of the AI tools that are currently on the market.
Wonderful. Thank you, Joe. And if there are any follow-ups to anything that we are chatting about, feel free to share those in the chat as well. We have a lot of great questions. I want to take this one from Allison. I feel like I've seen this come up a couple of times as well. How can we help our attorneys get over the "this is how we've always done it" mentality? I found that once I have been in a trial with an attorney, they see what I or other paralegals can do and use us going forward, but getting them to let me help them is the hardest part. So any advice here?
Yeah, brilliant question. I mean, look, you're talking again about soft skills and stepping outside the legal practice for a second. I mean, how do you engage with someone professionally who is not either recognizing the value that you can bring, not seeing the value that you can bring, or is not willing to give you a chance to see the value that you can bring until you've sort of gone through it, and then all of a sudden they're leaning on you a little bit more. I don't know if there's a uniform answer to that question, but I do think that there are some things that you can do that show the output of the value that you can bring. I'm going to I've seen it in the chat that some people are allowed to use AI, some lawyers are not letting paralegals use AI, some, whatever it might be. I really think that going back to AI for a second, the thing that I just showed you, for example, if an attorney is asking you to digest a great deal of information, give me a summary of this transcript, give me a summary of this deposition. There is an expectation in their mind of how long that's going to take. If you do that, and you're doing it obviously by the book, I mean, you're using something like using some sort of tool to help you get there. You get there quicker, and it's just as accurate, if not more so. And it has all the page line citations, and you can also then go back and ask it more questions where you say, not only here a summary, but I just asked it to give me a list of the 5 most important questions I can ask this witness at trial. And oh, by the way, I've also cross-referenced it with another transcript from an expert at the same in the later deposition. You're immediately shoving in the face of that attorney some value that you're bringing, not just because you're an innovative thinker, but because you are now freeing up your time to do less busy work and now actually handle some more tactical things that go along with that trial. That's just one example, I think, now that you have that you didn't have a year ago. So if there's ways to use some of these tools to show that you can actually be much more efficient with your time, and it's not a question, it's not saying before you weren't efficient with your time, it's just saying now you have more time to work more strategically and you are now more trusted because of the work output you've delivered to that attorney. I think that that is a great way of basically saying, what I'm doing speaks so loudly that you're not even hearing what I'm saying. My actions are speaking volumes. That's just one thing that comes to mind, and I've seen people deploy that brilliantly in the last few months.
Thank you for that answer, Joe. Moving right along here, like I said, we have a lot of great questions, and I'm glad we have, a good chunk of time left. Um, Gina is asking, number one, what do you find to be the holy grail for your personal trial preparation? And number two, what are the skills that the best support staff you've had in trial possess?
Oh, amazing. I love it. These two questions go hand in hand. Um, there's the image of the solo lawyer, the sort of To Kill a Mockingbird, walking into the courtroom by himself, um, done all the prep work, and now it's him against the jury, him against the community. That's a Hollywood, and we obviously have all these different Hollywood versions of how this goes. The reason I'm saying these two questions are conjoined is because it is imperative to me when I've been in trial before to be able to look to my right and have someone that I trust. And when I say trust, it means someone who is on the same page as me, someone who is in sync with me, someone who's done the prep work with me, who has led me through part of the prep work, someone who knows the flow of things, someone who can stay poised, someone who knows how to get answers. That very often, most of the time, that's not another lawyer. It's someone who it can be. I don't care what their role is, but definitely a competent, incredible, smart, brilliant paralegal is irreplaceable there. And the reason that your two questions are linked is because if you if you provide that value in advance of trial, then you are showing, I think that is the holy grail of paralegal skill set and any sort of skill set in support of or in conjunction with attorney skill set. Preparation and poise, like give me those two things any day of the week, and then I am sitting next to someone who I completely trust. If I can trust you in that setting, you are with me for life. And so those two things, I can't tell you how near and dear to my heart they are and how irreplaceable they've been in both difficult verdicts that I've received and really positive ones as well.
I love that. I love the emphasis on trust. Thanks, Joe. Looks like we have a few newer paralegals or newer legal assistants in the audience. Couple of questions coming in from them. Really, do you have any advice on working with new attorneys and not having trial experience? How can we best prepare? What can we anticipate? Really, they don't want to go in blind. Any advice there?
Yeah, it's hard. I mean, so much of this practice is in the early days is done by doing. That you can, it's the great truth about law school, right? lawyers go to law school for 3 years. They take the bar. They could go to the best law school in the country by whatever metrics people are using. And then they step into a courtroom and they're exposed. I mean, they don't know what it feels like and they don't understand how to react. And those skills, very often the soft skills, the ones that you have to learn as you go, are not taught. You only learn by doing. Now, there's ways to mitigate against that, right? I mean, there's ways to prepare. There's ways to sort of just have an understanding of how most competently to do your job and do all of those things with an awareness that the uncertainty that you're going to feel over time is going to diminish. I think that that's a critical part of your early days of your practice, whether you're a lawyer or a paralegal. It's really, really, really understanding that you don't know a great deal of things. So, in my opinion, it is being fearless with questions and not being fearless with questions. I mean, when you ask a question, it is because you've exhausted all the other remedies. If you're working with someone who is really invested in your future, they're going to be invested in making sure that you get your questions answered. Ideally, you're not asking the same question twice, right? You're learning as you go. You're picking up these skills and acquiring them as you move forward. The other thing is this network. I mean, if this network here, Paralegal Brief, I mean, if there's other local paralegal organizations, reach out to your peers. If this network is as chatty and as supportive and as curious right now, I've got to imagine that your peers locally and nationally are going to be a wonderful sounding board. Having a mentor in that space is critical. Someone that you can go to ask what people obviously always describe as the stupid question, the thing that you think sounds stupid and may be something you only need to ask once. But if you combine a fearlessness with your curiosity, with a ruthless preparation, and then the ability to sort of take a deep breath and realize that the first year, 2, 3 of your practice is going to be about knowledge acquisition and a recognition that you're going to take missteps, that humility plus that curiosity is, again, it's gold. You're setting yourself up and your career up for a great deal of success. And hopefully you return that empathy to someone new a few years down the road.
I love that. And we have had some more seasoned paralegals in the chat sharing advice along the way, which is always great to see. We have a kind of a fun question coming in from Rihanna. What is the worst possible thing, the most detrimental thing a paralegal could do during trial prep? What would you say that that could be?
Oh man, it gave me sort of chills thinking about that. I only because I've been there before. Um, I think that the quickest way, I mean, there's extreme answers to this question, right? But I think that the most common and realistic answer to this question would be if you truly, if you don't know how to prepare and you don't have the baseline of your job covered. Like if you, there was one time right before trial, it was a criminal trial, and my client was facing 25 years to life. Um, and the assistant, someone who was supporting that case, leaned across as the jury was being selected and said something like, "Is this person 25 to life?" And I looked at this person and I was so flabbergasted. How can we be this far along and that detail be overlooked? If that question is being asked, that is a long path to redemption in my book. I mean, those I need to be, you need to be so many steps ahead of that. And so to have that lack of preparation, I think is just fatal. The number of times you win on preparation is, I don't know, 90%. You might sort of lose, you might not get the verdict you want. But if you are the one that is always prepared to spin this positively, oh my God, oh, you will avoid being that sort of incompetent negative person in the room at the time that people are looking for the complete opposite skill set.
Thank you, Joe. All right, let's see. We have time for a few more here. I've seen a couple of questions coming in about trial binders. Number one, what kinds of documents do you prefer in your trial notebook, and what might be the best way for a paralegal to organize trial binders?
Okay, I'm going to answer that. Allison just chimed in. Sometimes your naive assistant can be an asset. If they don't understand your argument, the jury may not either. Okay, I love that answer, first of all. Um, I hope that your legal assistant is a naive one. Like, I love when you get outside people who have no understanding of what's going on and you workshop ideas with them. Is this an argument that's going to be compelling? Is this a thing that's going to be resonant? How can I take this complicated expert testimony and make it conversational? How do I pick a jury with the right questions? If you can get workshop those ideas with someone else, ideally, again, not your legal assistant being naive, but someone who has no familiarity with the case, I think that's brilliant. So I just love that point, Allison. Um, Trial binders. I imagine for those of you all in the chat who have been talking about the experience that you have, Teresa has 30 years and is learning more every day. Um, I imagine that the number of different hearings, trials that you've been a part of, this is going to be such an individualized thing. The things I want are very different than the things that I've seen other counsel really want. Some counsel want everything. The case law printed out. They want this, whatever, maybe the governing statute, the cause of action, all the pleadings, the transcript of all. Some people don't want any of that. Some people want to have a laptop and have it all accessible digitally. So a huge part of the answer to this question is knowing who it is that you're working with and what they want. If you are doing this blindly, if someone has just said, prepare a trial notebook for me, and you don't know, or you're not getting the feedback about how to build that in a way that you think is going to match what they're after, be over inclusive. Like don't trim things down because you think they're stupid. You can always cut. You can always pull a section from a trial notebook. You can very easily take out all of the printed out case law that has been relevant throughout. You can always remove a deposition here or there. You can remove exhibits that might not be, whatever it is. But if you go to someone with a trial notebook that is completely over comprehensive and then it gets pared down, it's a much better look than the opposite. And if you do that too, then what you're telegraphing and communicating is, I am on top of every single detail. Someone who walks in and I say, look, I only need half of this, versus the opposite, where I say, well, where's this, where's this, where's this, where's this? I am immediately sort of breathing much more easily with that person who has considered all the details. So that would be my word of encouragement if you're going into it blindly. Otherwise, workshop that with the person that is asking for the trial notebook.
I love that. Thank you. And again, lots of resource sharing in the chat. Love to see it. I do like this question coming in from Michelle. What is the best way to handle an attorney who likes to change the trial notebook exhibits right up until the last minute?
You know, that's a great question too. I do think that now, with the advent of a lot more digital tools, there can be a little bit more ease of doing that now, because when you're just reordering things or adding or removing things last minute digitally, then I think that even though it can be frustrating and it can feel last minute, and hopefully, again, it's done strategically and not out of laziness, but there are a lot of digital tools that make that process a little bit more easy. I'm going to talk about Steno again for a quick second, because they have a virtual deposition tool that allows you to upload exhibits in advance. And this question does come up a lot when I talk about that. How do we do it? How far in advance? What happens if things change? Having an ease of use to doing that, I think, is really valuable. And there's a lot of tools out there that can help you do that. But there is going to be the frustrating part that comes with these last minute audibles. If it's coming from a point of strategy and it's not coming from a point of laziness, excellent. Then you've got a lawyer who's working up until the last minute and really reconsidering how to tell that story. And the logistics behind that can be a little bit frustrating, but so it goes. But look at some of those digital tools if you haven't already.
I love that. Yeah, Steno really, really is changing the game. And I do just want to note for everybody, you will be receiving a few resources from them in your email that'll come to you along with the recording and a copy of these slides. Let's see, we have time for maybe one or two more. Sarah is asking just pretty plainly, what is the best way to make sure that everyone on your team is on the same page and equally prepared for trial?
Yeah, amazing. This is critical. It always strikes me. I'm not a huge football fan, but uh, you know, it's amazing to me on game day. There's always a moment where someone will talk about the head coach, and um, we're sitting back on a Sunday watching a football game, and it's a point of recreation, right? And it's amazing to me when they talk about the amount of preparation that these head coaches do with their staff and with their team. I mean, you're talking like 120 hours a week, and all for a game. Uh, it's amazing to me to think about that because then they play for 60 minutes. It's the same principle, whether you're a football fan or not, that applies to a trial. Ideally, you have a point person. Ideally, your attorney, the attorney that is running the show, is really not just an excellent courtroom lawyer and a strategic planner, but someone who really is invested on getting people on the same page. That person should be regularly meeting with the right components of his team at the right times to make sure that the strategy is seamless and so that you can walk into the courtroom or the hear deposition in advance and things are good to go. If that person is not doing that, if that's one of their weak points, which, sometimes attorneys are great in court, but not great when it comes to preparing for court, a value add that you could bring or could suggest is having those meetings to make sure that people are on the same page uh, and organizing them. And here's the time when everyone can get together, whatever it might be, depending on the case and who's involved and exactly what case you're thinking of when you ask that question. But there's always value in slightly over communicating. It gets to a point where meetings for the sake of them can be disruptive and a little bit tedious, but good planning meetings with clear, crystal clear sort of deliverables, agenda. This is what we want to accomplish. We just want to make sure that we know exactly what's going on, go over things one more time. That's brilliant. I mean, again, that suggests to me someone who really cares in the outcome, which is good for me, good for them, good for the client, everyone involved. So don't be afraid to suggest it if that's something that you're comfortable with. Don't be afraid to organize it if you have the ability to do so, but trust that instinct. That's a great instinct.
Thank you so much, Joe. With that, that is just about all the time we have for today. Thank you so much. Before we go, I just want to encourage you all to participate in the survey that will pop up in your browser when this webinar closes. This feedback helps us continue to produce valuable webinars that you all genuinely enjoy, just like this one. And if you have any topics that you're very much interested in learning more about, feel free to add those in the survey as well. We're always looking for ideas. We have lots of webinars coming up with Steno included as well. So thank you again to our sponsor, Steno. And Joe, a big special thank you to you for an incredible presentation and for taking the time to answer our questions and just be such a great resource. Thank you.
Absolutely. And Tara, if I may, just very quickly before everyone goes, don't hesitate to reach out to me. I know that you might have follow-up questions about anything that I talked about or showed. Please, please, please take my email down, reach out to me, and I'd be more than happy to get some one-on-one time with anyone who has questions about this. So thank you all. This has been brilliant.
Absolutely. And his email is also in the chat as well, so you can easily click. A huge thank you to all of you for attending. I'm so glad you guys have enjoyed. Again, my name is Tara, and I hope you have a great rest of your day and a great rest of your week. Take care.